That's our electronic gavel. All right, everybody, welcome to the Wednesday, January 17th meeting of the Courts of Justice Committee. The clerk will call the roll.
Stanley's not here.
Mr. Chair, you have a quorum.
Excellent. Thank you, MJ. All right, we have a couple of housekeeping things to knock out. We have two bills that need to be re-referred. So first I'll call up Senate Bill 225 by Senator Pekarsky. That needs, Chair would entertain a motion to re-refer the bill to Ed and Health. Is there a motion?
Second.
It's been moved and seconded. We re-refer Senate Bill 225 to Ed and Health. All those in favor, open the roll. Yeah.
Ayes 11, no 0.
Great, thank you. The second bill we need to re-refer is Senate Bill 526 by Senator Williams Graves.
So moved.
It needs to be re-referred to general laws. So moved, has been moved and seconded. We re-refer that bill to general laws. It has to do with house sale, realtor stuff. All those, can you open the roll, please?
Ayes 11, no 0.
Excellent, thank you. Okay, then we have four bills going by for the day. Senate Bill 571 by Senator Eben. Senate Bill 598 by Senator Eben. Got to remember not to call the general laws chair's bills on Wednesdays. Senate Bill 625 by Senator Bagby. And Senate Bill 648 by Senator Aird. I think we can do that in a block. Is there a motion that we take those bills by for the day in a block? All those in favor say aye. Aye. Anybody opposed? Okay, Senator DeSteff also, I think, wants to take one of his by for the day. Was that 193? 193? Okay, so is there a motion to take Senate Bill 193 by for the day? It's been moved and seconded. 193 by for the day. All those in favor say aye. 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 Anybody opposed? No. Okay, that's off our docket. So, we don't have anything left? All right. We have a couple left. So, first on the sign-up is Senator DeSteff. Do you still have one left? Yep. Oh, that's right. So,
It's the same as 3 or 4 other bills?
yeah, there's a bunch that are like, is yours a little different?
This is a task force.
It sets up a task force,
That's right.
and I'm not sure how you're handling fentanyl rules, but I'm happy to present and get it started off.
Right, yours, Senator,
What's the bill number?
it's 367. And Senator, is your bill the same as everybody else's except for the task force?
I'm not sure, I've not read every other bill yet.
Mr. Chair,
Counsel?
it includes the language that Senator McDougal and Senator McGuire's bills have about felony homicide, but Senator DeSteff's bill also adds some information about when the chief medical examiner will perform autopsies, increases the mandatory minimum fines for certain distribution, and also creates the task force. So it does those 3 additional things.
Okay. So it does a bunch of different things. So I guess we need to take this one up separate. What?
You want to have them all present? and then-
Yeah, why don't we have everybody present together and then we'll figure out how to,
Mine's very different from theirs.
yours is different?
Very. Mine deals with manufacturer.
Mr. Chairman, you may want to mute your mic, Mr. Chairman.
Yeah, that's different.
Yeah.
Yeah.
You may want to mute your mic because the closed caption picks up your private conversation.
So we have a couple, let's see. Well, why don't you go ahead and present yours, and then I know McGuire has a fentanyl homicide bill, and I think McDougal has one that's identical to McGuire, I think. Why don't we have the 3 of you guys go? Senator Obenshane's has to do with pill presses and things, which is a little different. So why don't we have the 3 of you guys present, and then we'll figure it out.
Great.
Okay?
Well, Mr. Chairman, members of the committee, I'll start with just kind of an overall overview. Everybody knows that fentanyl is highly potent synthetic opioid, 50 to 100 times more potent than morphine. Basically, 3 grains of it, the equivalent of 3 grains, similar to 3 grains of salt, is enough to kill somebody. We have a problem in the state of Virginia. It's the number 1 reason for death in the state of Virginia. Last year, there were 1,757 drug overdoses. I'm sorry, that was in 2020. And fentanyl is a significant issue with that. Nationally, there were 69,710 drug overdoses, roughly the same time period, and 60% of those resulted in deaths. The statistics highlight the severity of fentanyl crisis in Virginia nationwide. The potency of fentanyl and its prevalency in the illicit drug supply make it significant risk for overdose, even in small, very small amounts. It's essential that individuals who use these drugs, their loved ones, and healthcare providers are aware of the risks associated with fentanyl and take the appropriate steps to reduce the harm. This includes seeking treatment for substance and disorderly abuse, carrying naloxone, avoiding the use of the illicit drug altogether. And what we do here is we talk about the task force to educate, seek help, carry naloxone, dispose of the medications safely, support harm reduction efforts, advocate for change. By taking these steps, the public can help raise awareness of the dangers of fentanyl, reduce harm with the associated drug use, and advocate for change to address the fentanyl crisis, the number one killer of Virginians. Nearly 120 pounds of fentanyl has been seized by police. Locally here, we've had enough to kill every Virginian over 26 times. Let's see. Setting up the task force, enhancing the penalties the way we've suggested, and Senate Bill 367, I believe will help reduce that. And for those individuals who are involved in this, selling, distribution of fentanyl will be a little bit of a hamper and hinder the spread of fentanyl in the Commonwealth. And frankly, how many times do we need to have enough fentanyl to kill, our 8.5 million people? How many times? So thank you. I'll hand it over to the next one.
Thank you, Mr. Chairman, members of the committee. Senator Steph covered many of the points that I'm going to cover, but over the summer I had a roundtable with law enforcement folks, and I said, can you just tell me how dangerous fentanyl is? And two stories stood out. One of them said that his wife was washing an officer's uniform and overdosed in their laundry room. Another officer said he was doing a stop on Highway 95 and he found himself on the ground, frothing at the mouth, crawling towards his car to get his Narcan. He said he always has it on his side after that. It is very dangerous. It's being produced in China. It's coming across our southern border, and it's killing more Americans every year than died in the Vietnam War, and it's growing. So I'm introducing Senate Bill 602. The purpose of this bill is to bring Virginia's law in line with federal law. Under current Virginia law, drug dealers can't be charged for supplying drugs that result in fatal overdose. This bill would change that. Our country and Commonwealth is facing a crisis as the number of overdoses in the state is increasing exponentially. The way we can start to slow the flow of drugs into our Commonwealth and protect our kids is to hold the distributors accountable for their actions. An example of this bill has been done in Texas and Nebraska. And in Texas and Nebraska, they have the biggest increase, or I should say the biggest decrease in fentanyl deaths. So this bill would work. And so this gives our law enforcement officers what they need to save the lives of many of our fellow Virginia citizens. And I hope you guys will vote yes.
Thank you, Mr. Chairman and members of the committee. I think my bill number is 52, and I'm going to try to step through. I think you heard some of the emotional points around this bill, and you're going to hear some more of that from individuals who have lost family members because of fentanyl overdosing. But what I want to try to do is step through how we got to where we are and what we're trying to do in order to, in my opinion, address the issue. Back in the 80s and 90s, the case law was clear under the Heacock decision that when there's a homicide with the res gesta, means the time, place of the initial felony and its emanation thereof is committed in the perpetration of that felony, you have felony murder. So in that particular case, there was individuals who had cocaine. I think it was we were seeing a lot of fentanyl at that time, and they were cooking cocaine. They brought it to a party. They used one of the people used the cocaine. The other people went downstairs. They ended up getting ill from the cocaine, ultimately overdosing and dying, and they were convicted of felony murder. That was what people thought the law was in the 80s and 90s, and even after that. In 2000, and I believe this case was 2014, the Woodard decision came out. And in the Woodard decision, it was not dissimilar facts on the front end. There was the sale of pills. There was an individual who met Mr. Woodard, who met another two people in a parking lot. I believe that one was in Danville. And they sold them pills. Those individuals left the parking lot, did some other things, went back to their home that night, took the pills, and then one of them went into a coma and ultimately died. The testimony from the medical examiner was that they died from, I believe it was fentanyl that was in the pills. There was a prosecution. Mr. Woodard was convicted of felony homicide, and the Court of Appeals on appeal said the time from when the sale of the drugs was too long from when Mr. Woodard was shown the initial symptoms of drug overdose and then it ended up dying. The sale in the parking lot the afternoon to the beginning of death that night was too far, so it could not be felony homicide. And that's where we are today. So, Mr. Chairman, my understanding of the law right now is if individuals are using drugs together and one of them gave drugs to their friend, they're still eligible to be prosecuted under our current felony homicide statute if that death starts or occurs in that same time. So if they're at a party, somebody takes it while they're still there, they could still be prosecuted today. What cannot happen today is a person sells the drugs, you take it to the party, once you leave where the drug dealer was, then you lose the ability to prosecute the drug dealer, but the person still giving out the drugs at the party is eligible to be prosecuted. So what we tried to do with what you see before us is to address that situation of the person selling the drugs to people and penalize them, even though the time from when the death might have occurred from the overdose was not exactly the same time that the sale occurred, but make the penalty substantially less than what it is today for the people that are using it together at the party. I think one of the things that I think is fairly universal is, and we've tried it with a number of statutes, and you've seen me bring a couple of those that have passed, is we are not trying to increase penalties on people that are just addicts. We are trying to get at the individuals that are selling the fentanyl that are killing our children. And I think Senator, I don't know if it's DeSteph or McGuire indicated, we've been averaging the last number of years over 2,500 deaths in Virginia from drug overdoses. Those deaths are more than car accidents and gun deaths combined. Think about that. More than both of those things combined, people are dying from drug overdoses, and the vast majority of those drug overdoses in Virginia are fentanyl related. So that's what we're trying to do, is get to those individuals who are dealing drugs, reduce the penalty, which I think is in place currently on those people that are using them as an accommodation.
Before we get to your question, I just have a couple of housekeeping things I want to take care of on this first. Senator McDougal, your bill and Senator McGuire's bills are identical.
I didn't compare them exactly, but I think yes.
Yeah, council told me they're identical.
Okay.
So, and I believe you have the low bill number, if I'm not mistaken. Is that right?
I think you're right.
Yeah, you're about 600 clicks lower.
Yes.
So, Senator McGuire, you got any problem if we roll? Okay, so the chair would entertain a motion to incorporate Senator McGuire's bill into Senator McDougal's. Been moved and seconded. We have to record that, right?
Yeah.
Yeah. McGuire into McDougal. you open the roll, please?
Can you?
My apologies.
Sure it's not up there.
Yep. Yep.
Ayes 15, no zero.
Great, thank you. And then the second thing is, Senator DeStuff, I think you had a substitute.
Yes, that's correct, Mr. Chair.
Okay. So I'd entertain a motion to approve the substitute so we can have it for us. Been moved and seconded. We do the substitute. All those in favor say aye. Aye. Anybody opposed? No. Okay. So Senator DeStuff's substitute's now before us. I think Senator Stewart had a question for Senator McDougal.
Thank you, Mr. Chair. Senator McDougal, I just want to make sure I understand this because not really the area that I practice in anymore, and I used to understand the law, but I want to make sure that I have a good grasp on it. So if I understand what you're telling committee, if a college kid, let's just use a college kid for example, somebody at Randolph-Macon because it's close, and he gives 2 or 3 other college kids drugs, cocaine, whatever it is, as an accommodation, which is a term of art under the law. And 1 or 2 or 3 of those children die, that kid who gave them the drugs could be prosecuted, but not the one that sold them the drugs that were tainted. Is that the way the status of the law works today?
Mr. Chairman, I want to make sure, I'm going to try to be exact and have in one of my Commonwealth attorneys, Nate Green, if I need to tag a friend. But when you distribute drugs, accommodation is an affirmative defense by the defendant. So when you sell those drugs or give them, it's distribution, then the defendant has to come in and say, I did not make a profit on that. I gave it as a accommodation. And so that's where that person comes in. But you are correct. The dealer that sold the drugs that were given out under the Woodard case cannot be prosecuted for if somebody dies. I do not think there's a prohibition on them being prosecuted for distribution if they can make that establishment. But they cannot be prosecuted for the felony homicide.
Mr. Chairman?
Senator Stewart.
So taking out the part about the accommodation, if the kid who is friends with the other kids buys it from the other guy, takes it back, and sells it, can that kid then in college be responsible and be prosecuted for felony homicide, but not the dealer himself?
Mr. Chairman, today, yes, and my prosecutors gave me some examples of cases that they did. So I was not present for those cases, but I talked to him within the last hour to confirm I was accurate.
Counsel, can you all remind us what the penalty is for fentanyl distribution? What class felony it is?
First-time offense for the distribution of a Schedule 1 or 2 controlled substance is up to 40 years in prison. For a second offense, it's up to life in prison with a minimum mandatory of 3 years. For a third offense, it's up to life in prison with a minimum mandatory sentence of 10 years.
Right. Counsel, can you correct me if I'm wrong, but I believe the proposed punishments in this bill are pretty much identical, right? Except that it's a different label. It says, I think, 5 to 40 in this, and then,
That's distribution.
yeah.
Yes, that's correct. It's the same range of punishment, 5 to 40, as the range of punishment for a first offense of distribution of any amount of Schedule 1 or 2.
Right.
And the accommodation section that appears in subsection C of
Right.
Senator McDougal's bill would be up to 10 years for an accommodation.
Right. Got it.
Mr. Chairman,
Yeah, Senator McDougal.
As the committee is very well aware, it's not dissimilar to how we handle situations where a firearm is used, where you have the firearm in commission of a felony, and then you have the felony itself, which could be murder or malicious wounding as well. Both of those are traditionally charged if it occurs.
there any other questions for the patrons before we go over to testimony?
Mr. Chairman, I do think that there are a number of individuals who have some personal stories that were certainly very impactful for me that wish to present.
Senator, do you think the 10 minutes aside will accommodate the stories? I mean, I know a few of them.
I think so.
Okay.
I think you might want to take a little more time to listen to the Commonwealth's attorneys after that, just in case they have some other technical things, but my guess is that'll be a back and forth with committee members.
Okay. Why don't we go 10 minutes aside, see how it goes?
Come on.
Welcome to the committee. Go ahead.
Thank you. Good afternoon. Thank you for affording me this moment of your time as you take into consideration Senate Bill 52. My name is Jennifer Johnson, and like so many others here in the Commonwealth, my family has been forever changed by illicit fentanyl in the form of a counterfeit pill. In August of 2020, my 19-year-old son, PJ, and his girlfriend were preparing for the start of their fall semester when they attended an open mic event held in Fairfax County on the evening of August 8th. On August 9th, PJ did not get up for breakfast. After breakfast, I needed to run to CVS. PJ's car was parked directly behind my garage door, blocking me in, so I called his name and headed towards his room to get his keys. I called his name several times. He did not respond. I finally pushed in the double doors to his bedroom, where I found both of their lifeless bodies. We were able to access PJ's messages through his iPhone almost immediately. The last message he sent was to a DJ residing in Fairfax County that they had met the prior evening. The message expressed that it was nice to meet him, how much fun they had, and they hoped to do it again. The last line of the message was thanks for the perk. This individual read the message but never replied. This person has never been charged with any crime in association with the distribution of illicit fentanyl or the deaths that resulted from it. I would like to see our Commonwealth hold those distributing this deadly drug responsible for their participation in these types of events. And I'm a registered Democrat, and I'm standing here before you in support of a bill proposed by a Republican from a place that I honestly couldn't find on a map, because I just vote my conscience and I stand for what I believe in. And I guess I'm asking you guys to take my family and families like mine into consideration when you vote today. So thank you for your time.
Thank you.
Hi, everyone. My name is April Thomas, and I am the mother of Timmy Patterson. Mom, hold that up, please. I have the unfortunate view to see this from two sides of this world. I'm also a retired Virginia Beach police officer for 23 years. I know I look like I'm 16. But I have worked 23 years as an officer, and I revived people with Narcan and went to a lot of drug cases. And it wasn't until it'll be February 2 years that my son was killed by fentanyl. Had no idea that any of this was going to happen to me, and I will even be here speaking with you. He graduated top % of his class, went to school on a scholarship, church altar. He did everything right. And one moment, one pill, one incident changed his life forever. And we have messages from the people that sold it to him. No one's been prosecuted. Should you make a choice to get a pill, whether it's a Tylenol 800 because you have a migraine or a Oxycontin, it shouldn't be a death sentence. And should that happen, there should be accountability. Should I arrest somebody for DUI, and I have made many arrests for DUI, whether they were twice the legal limit or just meeting the legal limit, it was still a crime to drive as if you were under the influence. So the levels didn't matter. The time frame shouldn't matter. If they are found to have sold someone drugs, they should be held accountable on this level, just as we see as the domestic violence charges or DUI. I can go on and on. I want to give everybody the opportunity to speak, but we just have to do something. Thank you.
Hello, and thank you for your time. I'm Melissa Baker, and this is my husband, Ken, and we are the parents of Kendall and Baker. Kendall died at age 32. Kendall struggled with depression and anxiety She took prescription Xanax. She needed more. She bought some from a friend or someone she thought was a friend. We have phone records that show they talked 5 times that night. We have old text messages that show that she bought Xanax from him. I left her on Friday, the 25th of February, and told her I'd pick her up on Sunday morning. My husband found her in the afternoon of the 26th. He found her lifeless body. There was not even a reason to try to save her. She was gone. The police were there. They kept me from being with her, would not let me see her. There were no charges filed. We know who she bought it from because there were 5 phone calls that night, and there was a note on the computer that says he owes me $5 the next day. He is now waiting for a court date in Hanover County for manufacturing and distribution of Schedule 1 and 2 drugs. That has been going on since last March. We need to have justice for Kendall and for all the other people that are the future of America. It's killing a generation, and they don't know what they're getting. Kendall mattered. The police made me feel like she didn't. There is no court system to say that she did, but she mattered. Justice for Kendall Baker. Thank you.
And for those attending virtually who would like to speak, please raise your hand electronically now.
My name is Sean Foster, and this is my son, Caden. I'll speak a little bit more at length in a few minutes, but I just wanted to say that I understand that this bill or similar versions of it have been under consideration for years now. It's time to do something different. This drug is different. It's time for a different approach. It's an epidemic that's killing our children and killing our future. Thank you.
Good afternoon, guys. I'm sorry, I'm very nervous about being here. Thank you for letting me talk about my personal story. My name is Jill Chikowitz. I grew up here in Richmond, military family. My dad was an Army pilot and officer. I'm the 5th kid, but I tell everyone I'm not the 5th kid. I have a twin brother, Scott, so we're the babies of the bunch. We grew up here. We went to school here. We went to VCU. After 2 years of going to college, Scott decided he was going to go to LA, live the good life. He did. My older brother lives out there. He wanted a piece of that action. He started running gyms, started doing very well. Until 2014, he got a back injury, and he was put on Oxycontin, which I'm sure you're all very familiar with, through workers' compensation. Scott was on pills for 3 solid years. We did not know how bad it had gotten. I was an Army wife. My husband was overseas quite a bit. I know Scott's speech would slur. He would miss days at work. He was always absent. It wasn't until the Costco pharmacist realized he's overprescribed. He had 90 pills a week by 4 doctors being prescribed. They cut him off, and now he's in withdrawal. And if you've ever met anyone who's in withdrawal, it's the worst pain of your life. He would tell my mother he would blow his brains out with a gun if he wasn't scared he'd go to hell. Scott turned to a friend. This was not a friend. This was a drug dealer who gave him what he thought was Oxycontin. Scott went into Starbucks, took the pill, came out, put the cup of coffee on his car. He dropped to one knee, and he struggled for 20 minutes while everybody watched him. Scott died from fentanyl toxicity on February 28th, 2017, and my life has never been the same. It has cheated my children from the mother they had, my children from the daughter they once knew, and the person that I used to be. I'm begging you to remember Scott's story and everyone else here today and think about that before making your decision. Thank you for your time.
Are there online people that want to speak?
No, y'all come on.
My name is Faith Silvera. You all met me last year when I was here speaking for HB 1455. This is just a small representation of the families in Virginia that are impacted. And we need everything. We need rehab. We need programs of education awareness. But we do need to elevate that these calloused dealers who are not necessarily user dealers, but they're making a high profit off of selling the fentanyl pills. And as you heard, there's many times over people in Virginia could have been killed by the number of pills that were confiscated. But my niece was 18. She was on full scholarship at Bridgewater College. She died in March of 2021. right in the year of COVID, so she had all the hard things about college, but not the fun things. So she was slowly drawn away. We think that she had taken a couple of what she thought was a Percocet pill. The way these pressed pills are, you don't know if there's going to be a small amount or enough to kill 4 to 6 people. So in that case, she took a Percocet. She died that night. It's very shocking to lose a family member that way. She was 18 with her full life in front of her. It used to be people could experiment with pills and they could, get away with it. Not now. Taking a pill that has a fake pill that it's now Percocet, Xanax, and Adderall are 3 most common. And your life can suddenly be snuffed out. And we need the impact statement, the fiscal statement for this. I'm actually speaking for the other McDougal's bill right now, but it would only be put 6 people in jail for a year. That's 6 of the most hardened dealers. That's not every Tom, Dick, and Harry that might be selling to their friend or trying to make a little bit of a profit. These are the hardened dealers. So I ask for you to consider supporting all of these bills. Thank you. By the way, the dealer for my daughter, her own sister had died 3 months before in the same house. And then this particular person was never charged. A year later, gave a pill to Deborah Frisk's son, and he died also from 1 pill. So from this one person, we know that 3 people have died.
My son, Keen Harper Frisk, did not know this girl. He was kindly asked to take her to her PO officer in Harrisonburg, Virginia, on a Friday evening because she had no transportation. So he goes to Waynesboro, Virginia, picks her up, takes her into town to see her PO officer. From there on, she consumes his whole day, and he did not want to partake in it, but he did because he was a kind individual. He ended up coming home late, and it was like the next day on a Saturday, he ended up Sunday, Super Bowl Sunday, I found him dead. She had given him a pill for all his kind help. So, yes, something has to be done. We cannot. Our families are being traumatized. And, no one's mentioned, but babies are dying, you all babies. So please pass these bills, please.
Thank you. MJ, the online people, do we know if they're for or against?
Donna Watson, you may unmute and speak.
Okay, we've already exceeded our time, so if the people online could keep it to 1 minute apiece.
Yes, I will. Hi, my name is Donna Watson, and my son passed away in 2018 from fentanyl poisoning. And I wanted to show you a picture so you would see my son. He is a person, he did cancer. But I really wanted to plead with everyone there. I don't care if you're Democrat, I don't care if you're Republican, I don't care if you're liberal or conservative, it doesn't matter. We all need to come together. We need to hold the dealers accountable. I have done everything in my power, and I will continue. My son's life evidently didn't count back in 2018, but if I can save another family from going through what I've been through, it will be well worth the fight. I am pleased with you guys to please find this bill and approve it. And thank you very much.
Support this bill.
Can we get one more?
Sarah Link, you may unmute and speak.
Can you hear me? Hello?
Yes, we can hear you.
Yes, we can hear you. Please
Can't
go
hear you
ahead with
now.
your testimony.
I think you just muted yourself.
Please unmute.
We can hear you. Please go ahead with your testimony.
Yes, I'm here representing several organizations that represent victims in Virginia. Drug-Induced Homicide Foundation is in support of this bill. The Association of People Against Lethal Drugs is in support of this bill. VA Moms, Michaela Cherie Foundation, the Michael Lee Warren Movement here in Virginia, and many, many other victims that I have personally spoke with in Virginia are in support of this bill.
Hey, thank you. I want to thank everybody for taking the time to come here to tell us your stories today. We appreciate you all making the effort to be here. And now we need to move to the people that are opposed to the bill. Yeah. Yeah. Is there anybody, I'm sorry, is there anybody else in support of the bill that can testify? Just want to tell us they're in support?
Mr. Chairman, I think a number of people from the Commonwealth's attorneys, different prosecutors are here, and I think the Sheriff's Association.
Good afternoon, Mr. Chairman. Nathan Green, Commonwealth's Attorney for the City of Williamsburg and James City County. A lot of what I would say has already been said, much by Senator McDougal and the other senators. I could help answer if there's still any confusion about whether someone could be charged with felony murder. The best way I can explain it is we have hotels in James City County, and if a drug dealer comes and hits 4 of the hotel rooms and sells drugs to 4 individuals and then leaves, and those 4 individuals die, we cannot prosecute him for felony murder. If an individual picks up some drugs and goes and meets up with his friends in a hotel room and stays there and is there when the overdose happens, that person can be charged with felony murder. A lot of times, because of that relationship, the individual that is just there in the hotel room is there because it was an accommodation. They were the ones that went and got the drugs, but by bringing it back to the hotel room and handing it to their friend, that's distribution. And so we can go after those individuals, and that individual faces up to 40 years, unless you pass Senator McDougal's bill, which would cut that down to a Class 5 felon.
So, Mr. Green, so let me try and... You're basically looking to be able to charge people with 2 infractions if they deal a pill to somebody and they die, the distribution and murder, so that you can get them for, what, up to 80 years instead of just 40? Is that an accurate statement?
It is, Your Honor. That would be the result. I wouldn't say that that's our goal. In order to answer that question, Mr. Chairman, I would point out that on a distribution, your starting point on guidelines, and guidelines are very well respected by all the judges, your starting point for a distribution is 12 points, which equates to a 1-year midpoint. If you are convicted of felony murder, your starting point is 205 points, 17 years as a midpoint. So there's a dramatic difference between felony murder and distribution. Even though the sentencing ranges are almost identical, the midpoint on a felony murder is 16 years more than a distribution, which is just 1 year.
Mr. Green, isn't it true the sentencing guidelines are based on the sentencing conduct of our existing judges on cases within certain classes? That's what they tend to base them on, right?
Mr. Chairman, they are. What is frustrating about the distribution guidelines, if you go through the distribution guidelines, if the facts are that your distribution killed somebody, your guidelines do not change. And there is an argument that just because someone died as the result of your distribution, that may not be relevant. The judge may not allow that to come in, because what does the result have to do with whether you distributed narcotics? So you could be in a position where your guidelines are 1-year midpoint with nothing to reflect that as a result of your action, someone lost their life.
Mr. Green, would you agree that it's sort of materially different if when you hand drugs to somebody and you're in the room with them and you stay in the room with them while they administer it and they die and you're sitting there watching that happen, that's materially different than the consumption and death happening outside of your presence when you can't really do anything about it? Would you agree there's a sort of a difference in the culpability or the ability to stop the death, et cetera, in those scenarios?
I would agree that there always going to be an analysis of a culpability. But I would find the individual that hits 4 houses, not knowing those individuals, not friendly with them, they're just his customers, and he kills those 4, I would find them more culpable than the individual that brings the drugs back to the friends in the doorway. That's
Green,
my own analysis.
I got it. I appreciate there's a policy choice in there somewhere. But one other thing I would just ask you, wouldn't you agree that in other areas of the criminal law, for example, reckless driving, or I've even seen people be killed, pass away from like making an illegal left turn, that we don't base the quantum of the punishment always on the conduct unless it's intentional. There has to be a level of intent involved before you get to murder land on something like that, right?
Mr. Chairman, I do appreciate the question, but I don't know that I would agree. Manslaughter is a perfect example. if you convict somebody of manslaughter, and it's simple manslaughter, again, we'll go back to the guidelines. The starting midpoint would be a little bit more than a year. It's 19 points as opposed to that 12. But if you convict them of aggravated manslaughter, if you present evidence that this individual got so intoxicated and drove so poorly, then we get up to aggravated manslaughter with a starting point of 71 points, or midpoint of 7 years. So I do believe that at times we look at just how culpable, just how reckless were you being, even if it was unintentional. We understand that these drug dealers are not trying to kill their customers. They'd like them to keep on buying their drugs. But we do punish extremely drunk driving more significantly than we do just normal manslaughter. So there is examples of where the quantum of culpability in your act is punished more significantly.
I have one more question for you really quick, and I just want to confirm whether your experience is similar to mine, although I don't represent, I don't do any of these kinds of cases very often, but in my experience, in what I've seen in court, would you agree that often, I don't know how frequently or not, but often, people that are dealing drugs, whether it's fentanyl or heroin, cocaine, marijuana, whatever, are also or can also be sort of heavy users or addicts themselves that end up dealing in part to feed their own habit because they're also an addict and they're also sick.
Mr. Chairman, certainly. In James City County, the vast majority of our drug dealers are in fact addicted to drugs. Right. That's of no solace to the family of the dead individual who died from the poison that was being sold.
Okay. Does anybody else in the committee have any questions for Mr. Green? My intention is to have everybody else say who they are and they support. I don't know if anybody else has any questions, Mr. Green. No? Okay, just who you are and organization support.
Mr. Chairman, I'm John Jones, representing the Virginia Sheriff's Association. We strongly support the bill.
Thanks, John.
Good afternoon, Mr. Chairman. Rusty McGuire, the Louisa Commonwealth's attorney. By the time y'all go to bed tonight, 7 more people will have overdosed and died in Virginia alone. It was 107,000, the CDC reports. The 22 results, we don't have the 23 results. That's from 27,000, the first year I prosecuted one of these cases. There was a young lady who died. 26,000, right. We're now 4 times that. Thank you.
All right, thanks. Again, state name, organization support, even if your senator's a brother.
Mr. Chairman, Robert Tracy with the Office of Attorney General. We strongly support this bill.
Okay.
Thank you.
Thank you. All right.
Mr. Chairman, there's one thing that you went through the questioning with Mr. Green, and I just caused it, and I certainly it's been a long time since I've prosecuted cases, but when we look at other types of homicide, we do look at additional actions. If you shoot a firearm into a house or into a car, that is a separate penalty as opposed to what happens once that bullet enters that house or vehicle. When you use the firearm in the commission of a felony, there's a separate penalty from what happens with the felony. So I would disagree with the sentiment that this is far afield with using the activity of distributing a drug that we know is going to kill in minuscule doses from something else.
Senator, wouldn't you agree that typically we use the term murder to refer to when somebody intends to kill a person as opposed to somebody engaging in extraordinarily reckless conduct where they maybe didn't necessarily intend to kill somebody, but they were just doing something incredibly dangerous?
Homicide might be the more appropriate term.
Okay. Okay, now we need to move to those opposed. Can we reset the timer?
If you would like to speak to this bill virtually, please raise your hand electronically.
Good afternoon, Mr. Chair, members of the committee. Sean Winneto speaking on behalf of the ACLU of Virginia. I'd like to run through one of the scenarios that was put forward by the support of this bill, and specifically the going to 4 different hotel rooms or 4 different hotels in the area and distributing fentanyl to different people in those rooms. The opportunity right now is already in place to charge them 4 times and serve them with 160 years in prison, if my math is correct. that person would have to die 2 lifetimes before they get
Mr.
out
Chairman,
of prison.
Can I ask a question?
Senator Stewart.
You mean for
Stop the
distribution?
timer there.
Correct.
And what would the likely sentence be for 4 counts of distribution?
I believe that a court would take into consideration, Mr. Chair, Senator Stewart, I believe that the court would take into consideration the fact that somebody actually passed away as a result of that distribution. I would also point out that, in fact, sentencing guidelines that are put in front of the court are, in fact, discretionary. And I'll use myself as an example on this. Most of the people on this committee know that I spent 16 years in prison. I had a 30-year prison sentence. Sentencing guidelines for my embezzlement were about 3 to 5 years, and I received a 30-year sentence. So the courts already have the discretion to impose any sort of penalty that they want within the statutory guidelines of the crime charged and convicted.
Is your question answered? Or? Yeah. Okay. Go ahead.
So
restart the timer.
So further, again, the court more than has the ability, law enforcement and the court more than have the ability to charge and punish these offenses. If we are looking for a deterrent value, the punishment deterrent is already there. And it hasn't worked. We would simply be doubling down on policy that we already know doesn't work. I'd also like to point to some of the chilling effect that this bill might have on our safe reporting of overdoses policy that's been in place and has been really supported in a major bipartisan way in recent years. I actually trained for the Department of Health. I'm an instructor for the Virginia's Revive Overdose Reversal Program. And one of the things that we train people in, and I do this all over the Commonwealth, from schools to first responders to people in recovery residences. And one of the things that we teach them is that if you are in a situation where somebody is in an overdose, that you can call for help. You can call EMS, and you can get them the help that they need. They need it now, and they need it quickly. Unfortunately, what this is going to do is it's going to lead to situations where people are not going to report. They're going to abandon them. They're going to put them in closets. We heard a story like that a few years ago. We've even heard of professional athletes in in Loudoun County. There was a young woman who overdosed in the apartment of a professional football player here in Virginia. And unfortunately, because of fear of punishment, rather than actually reporting that overdose to people that could actually get that person help, they put them in the backseat of a car, put that young woman in the backseat of a car, drove them to a hospital, and dumped them outside the door in the breezeway of the hospital. So it's going to have a chilling effect on that. In fact, more people will die because they'll be scared to report. More people are reporting overdoses right now because of the work that we've done. And this bill would have a chilling effect on that opportunity as well. Thank you.
Mr. Chairman, can I ask the gentleman one more question?
Sure. Senator Stewart.
So help me with this. What do we do to hold these people accountable? Because you got to figure they know they're selling something that either probably will or might kill that person, and they seem to not care. So do we just let them go and not hold them accountable? Is that the answer?
Senator Sorvell, Senator Stewart, the opportunity to hold them accountable, I believe, is already in place. The opportunity to charge them with distribution is already there. If crimes are not being charged, and I heard some really compelling testimony earlier from witnesses who talked about how people were not charged. The ability to charge those people was there. If a Commonwealth attorney is failing to actually exercise or a local law enforcement is failing to use their ability to actually charge that person with distribution, which is already available to them, that is not a problem of lack of penalty or lack of code on the book to actually be able to charge them. That opportunity is there. That is a prosecutorial discretion issue that could be addressed by the voters, certainly in that area, because the Commonwealth Attorney is accountable to the voters.
Mr. Chairman.
Senator Stewart.
And I'm kind of likening this to products liability. I'm having a hard time in my mind, and I realize I don't have the strongest one on this dais. But if we hold people accountable that sell defective products in the civil world, and we should. But yet what you're saying is if you sell a defective, deadly product that you probably know is such, and you probably know the result, it's just enough if we charge them with the crime of selling it and not hold them accountable for the end result. And I'm having a really difficult time with that.
Mr. Chair, Senator Stewart, I would push back with that a little bit. I think we're making an assumption here that people, in fact, know, have general knowledge that, in fact, that this substance that has been distributed is in fact, a substance that might kill the person they're giving it to.
Okay. Mr. Benjamin, question for you. And correct me if I'm wrong, but I believe that the Court of Appeals just came down with a decision en banc, I think 15-2, a month or two ago, where somebody was charged distributing a mixed substance. I can't remember whether it was in one pill or not, but I believe the Court of Appeals affirmed the idea that that the Commonwealth has an affirmative burden to prove the person knew all of the different substances that were in the pill in order to convict them of distribution of those multiple substances. It was a 15-2 en banc opinion that just came down, I think, within the last 60 days. Do you? Maybe even yesterday. It might have come down like in the last 5 days.
Mr. Chairman, I'm sorry, I'm not familiar with that.
Okay.
No.
I'll go look it up while we're talking here.
What I can tell you is that, Mr. Chairman, the Court of Appeals, in a case almost identical to the sort of situations we've heard today, ruled that victim impact testimony, including written statements from the survivors of those who tragically lost their lives, was both relevant and admissible at the sentencing of somebody convicted of distribution.
Right. Yep. Thanks. Okay. Probably. I'm sorry, did I cut off your answer to the question?
Mr. Chair, no. Unless the committee has any more questions for me, I'm done.
Okay.
Thank you.
Next up.
Hi, my name is Shnoa Young, and I am here to ask you not to support this bill. Yesterday, I celebrated 27 years of sobriety, and I did that because a judge saw me and sentenced me to rehab and not prison. These people need treatment. We have a drug problem. This is not an incarceration problem. If we keep sending people to prison, all we're doing is filling up these prisons. I ask you not to support this bill. Thank you.
Rob Hogan-Class from Justice
Rob,
for Virginia.
Desist for 1 second. The opinion, I think, was Kaman versus Commonwealth. It was decided yesterday. If anybody else wants to look it up while we're going. Mr. Pogenglass, go ahead.
Sure. We oppose the bill. For the last 50 or so years, we've been ratcheting up the penalties. Everything's been going in basically one direction. It's not working. We've heard here today the overdoses have been rapidly increasing over the last 10 years. It's not because of an inability to prosecute the people. There are plenty of laws on the books to hold people accountable. The fact is it's trying to control the supply side is not working. We have to work on the demand side. We have to help more people have more access to more treatment. That's not this bill. We oppose this bill because it does increase penalties, and we would like to see a different approach. Thank you.
Okay, is there any further, is anybody online testify opposed to the bill? Okay, so now we have two bills left, right? Two bills before us, and we need to, does anybody in the committee have any discussion? See, it looks like Senator Perry, you have something you want to say?
Mr. Chairman, I just have a question. And I apologize to the chair because I stepped out, but I understand that Senate Bills 52 and 602 were rolled into one.
Yes, I think that's right.
And I understand that was based on the understanding that the language of the two bills is identical.
Right. McGuire was rolled into McDougall.
Right. And I'm just looking in the system, but I would just, it's my reading that they are not identical. Senator McDougall's bill, for instance, has a little 1 and then a little 2 and talks about proximate cause of death. Senator McGuire's bill does not have that. And so I just wanted clarification on if we're rolling them together. I mean, they're nearly identical, but not identical. So which one are we voting on?
Counsel, can you, you're working for McDougall's right now, but Counsel, can you
Yes, Mr.
amplify
Chair.
where we are?
Yes, Mr. Chair, I apologize. Senator Perry is correct. Senator McGuire's bill reads just as a result of the distribution, the death as a result, and Senator McDougal's has the language results and then has a third clause and also requires that it be the proximate cause of the death. I believe Senator McGuire's is similar to the versions that have passed in the House before. They strike the additional requirement to prove that it was the proximate cause, so it is worded slightly different. Senator McDougal's bill is identical to the bill from last year, so I apologize for the distinction.
Got it.
So, Mr. Chairman, if I understand that, then my version is more restrictive. The Commonwealth's burden is more than what I guess the original House version had been.
And Mr. Chair.
Yes. Go ahead,
Yes,
Counsel.
Senator McDougal's bill is worded, and such person's death results from his use of the controlled substance, and two, such controlled substance is the proximate cause of the death. And Senator McGuire's bill just requires that such person's use of the controlled substance results in his death.
While we're focused on this, while we were up here, I just did a quick search to see if we've used that results in concept anywhere in Title 18.2, and I could only find it used once before, actually in a bill we considered last hearing, Senator Evans' bill involving, I think, abuse of pets or something. But that concept, results in, doesn't seem like language that appears in the criminal code very often. Proximate cause, different issue, but it seems to me proximate cause is more legally defined than results in, if we're going to go down this road. Mr. Benjamin,
Mr. Chairman,
have you looked at any of that?
Well, you're correct that the bill, as well-intentioned as it is, raises questions about application. For example, if the defendant sells cocaine to a person, that person then drives, speeds crazy, 120 miles an hour, loses control and crashes, killing himself. It appears that the defendant, who originally sold the cocaine, would be guilty of felony homicide. Perhaps he should be, but I think that's a reach beyond what is intended here. But that's one of the concerns that the lawyers would have in distinguishing between the reach of the statute to those distributors who know that they are selling or should know that they are selling a dangerous drug to somebody, fentanyl, and those who are selling something that is not, something like cocaine, for example, and then somebody's intervening criminal act of driving while on the influence of cocaine causes them to kill themselves. I don't think that's the reach, the intended reach of the bill.
Mr. Chairman,
okay, Senator McDougal, you want to respond to that?
On lines 21, I think as Senator Perry pointed out, little I, such other person's death results from the use of the controlled substance, and, so Commonwealth would have to prove both, such controlled substance is the proximate cause of the death, and then the rest of the language deals with the Woodard case about the regardless of time, place, death occurrence in relation to the commission of the underlying felony. So it doesn't stop the government from having to prove those things, puts in an extra burden on the government. Again, Mr. Chairman, I would say Senator Perry's prosecuted much more closely in time than Senator Stewart or I ever did, but this was the law that everybody thought was in place prior to the Woodard case. This was not, and then that appeal, that decision changed it, and here we are.
Well, maybe somebody can answer this hypothetical for me. I don't know whether it's Senator McDougal, you want to take a shot at it, or counsel can. But suppose, for the sake of argument, somebody distributes heroin to, say, person A distributes heroin to person B. Person B, who now has the heroin, cuts it with fentanyl, and then distributes it to person C. Person C dies. Does that mean we can prosecute person A, who's now one or two steps removed from the original distribution?
Mr. Chairman, I would say no. I would say no because the distribution was not the controlled substance. So once the fentanyl was added, was a subsequent act, the person's A distribution was of heroin, the government would have to prove that it was the heroin that was originally distributed that caused the death, that resulted in the use of the controlled substance. So it would have to be resulted from using that heroin, and that would have to be the proximate cause of the death. So I don't think they would be able to convict person A. You'd be able to convict person B.
The council concur in that?
It's not a case I would want to defend.
But that's a yes.
It's unclear from the statute. And certainly any vigorous prosecutor would charge person A.
Okay. Okay, does anybody else have any other questions? We'll figure out what to do here. Okay. So Senator Boysko, I think, has a motion she wants to make on one bill, but I don't know if we want to.
Mr. Chair.
No?
Mr. Chair. I've been waiting to speak for a while.
Oh, I didn't see. I haven't been paying attention to the queue here on my screen. Sorry.
And to address your hypothetical, Mr. Chair, your hypothetical and Mr. Benjamin's response, in that hypothetical, if the medical examiner said that the heroin caused the overdose, then A would be prosecuted. But I think if you have marijuana and A sells marijuana and to B and B puts in the fentanyl, clearly the marijuana is not going to cause the overdose and the death. We are putting out hypotheticals that are highly unlikely. What the point of this bill is, do we want people to continue to put into the stream in the Commonwealth fentanyl that is killing our citizens at an ungodly rate? Is that what we, as a Commonwealth and as a General Assembly, want to condone, or do we want to put a stop to it now? We have got to stop people who are putting fentanyl into our children's stream and into their mouths through other pills and killing them. They are dropping dead. We have had the people here testify. We've been hearing them testify for 3-4 years. The rate that children are dying and young adults unexpectedly, unintendedly, because they do not know that these products are laced with fentanyl. That's the issue before us.
Thanks, Senator Peake. Anybody else have any comments?
Mr.
Yes, Senator Boysko.
Thank you, Mr. Chair. What I've heard today clearly says that we have the ability, prosecutors have the ability to charge under the existing statutes for distribution, which could punish the people who are causing this harm. I serve on the what has been called the Substance Abuse Services Commission over the past 5 years. The experts in the field who are in these areas working with these individuals, from the Department of Corrections to the people who work with individuals who are addicted to these substances, agree wholly that further criminalizing is not a deterrent to these individuals. Their brains are not working properly. It does not stop the individuals from continuing to try to push these things. Now, I understand wanting, if punishment is the issue here, I understand what you're saying. I come from a position of that we try to restore and find restoration. But I have enormous compassion for the families who have come here and shared with us today. And I know that we have another bill that one of you has that talks about putting a commission together to look at this more deeply on how we can bring the police and sheriffs to make sure that they're approaching this in the best way possible. But because, if we go back and look at the 80s and being tough on crime, that didn't end up helping people get off drugs and save people. It just put a bunch of people in prison who have really been, it didn't solve the problem.
Senator Stanley.
Thank you, Mr. Chairman. You know, I've been a criminal defense lawyer for 30 years. I do believe that as we've softened some of our bills in criminal justice reform, there are many of my clients and their friends who know that. And in some ways, what I think sometimes we forget is that deterrence does occur when they know that they could be charged with murder. And then they make that decision. That's a decision they've made and the peril that they may face if someone dies. And just looking at the 2022 statistics in Virginia tells me that we've waited too long to pass this bill. Last year alone, 2,490 drug overdose deaths occurred in this great Commonwealth. Almost 8 out of 10, 79% of those drug overdose deaths involved fentanyl or fentanyl analogs. This is not just a batch of bad heroin. This is a killer. And until we are serious as a community and as a government to make sure that everyone who deals in fentanyl knows that if you deal in fentanyl and you kill somebody, you're going to be charged with murder, then this will continue. Hoping that people will just stop is ignoring human behavior. Punishing them for their bad behavior is the only thing we can do here, while at the same time trying to educate everybody on the poisonous fentanyl and its effects. We've been doing that. Story after story in the newspaper or in the TV news records fentanyl death after fentanyl death. How many, ladies and gentlemen, of those 2,490 Virginians who died of a fentanyl overdose or fentanyl after taking a fentanyl analog would be here today if we had passed this bill 3 years ago? And for me, if we save one life, we're doing our job. I believe that this bill is going to save many lives and tell those that deal in fentanyl that they do so at their peril. Thank you, Mr. Chairman.
Thank you, Senator Stanley. We need to get this hearing, we need to move on, but I thought it was important that we could give a lot of time. It was a very important issue, and it's definitely affecting our Commonwealth.
Just to close.
Mr. Chairman, if I could say one thing, and I'll be fast.
Okay, well,
when everybody's done.
All right, Senator Perry, go ahead.
Thank you, Mr. Chairman. I'll just say this. Look, I was a prosecutor for many years. I've dealt with this for a long time. I dealt with fentanyl before it was fentanyl, whenever we had heroin, and before we, quite frankly, dealt with a lot of heroin. I remember the progression of this. I remember whenever OxyContin became abused and people then switched to heroin, and then when heroin no longer really exists, it's all fentanyl or carfentanil or other drugs like this. And for what it's worth, I agree with the proposition that fentanyl is a different drug from the other drugs that we see that we have been dealing with. I think it was referenced here today that we've seen this increase in overdoses over the past 10 years, so that's how we know nothing we're doing is working. I would take slight issue with that because I think a lot of the overdoses are because there's a new drug on the streets that people are using that are killing people who have no intention and don't know that they're taking it. What I will say is that this is a substance abuse issue. I've also worked extensively with our drug courts. And substance abuse is a mental health issue. It is an issue that requires treatment. And I think that we can look at this issue from a variety of ways to try to deal with it, to try to attack it, to try to take it on. I think treatment is certainly an issue that I fully support, and I think we need to put a ton of energy and effort into that. I also think that bills like this have multi-facets to it, and there hasn't been a whole lot of discussion today about the accommodation provision of this bill. The whole point of accommodation is to try to remove from the statute people who are what we call user dealers. The folks who are struggling to get by, who are using drugs and dealing drugs just to try to get to the next high, to get to the next thing. The statute lays out trying to remove those people from penalty, from prosecution under the section. It's the second part, and I apologize, my screen has gone to sleep. But I think what this bill also does, though, is allows you to go after the people who, I know the four hotel room example is given. Quite frankly, I don't think it's a great example, right? I think if you use words like traffickers and things like that, it helps you understand. This allows you to go after those people, the people who are out there, with a total different intention in mind. I think another thing we haven't really discussed here today is the fact that if you are convicted of felony homicide and distribution. Those are two separate offenses that occur on your criminal history. When a prosecutor picks it up, they are able to see not only that you distributed and how much time you got for it, but that you murdered someone, you killed someone whenever you distributed. That is important because if you come back into the criminal justice system and are back on another charge of distribution, it would matter to me as a prosecutor if you have previously distributed and taken someone else's lives. It is a factor to be able to know, to be able to consider, and that is one of the easiest ways to do it. Certainly every single judge has the ability, as we've talked about here today, to look at and consider the facts and circumstances of your distribution and take that into account in whatever sentence that they impose. And I think that is important to have. I will also say, it was also mentioned here today, the what we call the safe harbor provision that was passed many years ago. It is my understanding, and I certainly didn't serve in this body at that particular time, that those two bills went up together, a felony homicide bill and the safe harbor provision, because we were trying to do both. Provide that when people call, they have the safety and security of not being prosecuted. They have the safety and security of calling to save their friend's life, to save a stranger's life, to save whoever's life it is. And it's certainly something that we all should work towards and try to do. But this bill was to help deal with the folks who are trafficking in heroin and fentanyl that is taking people's lives and is an extreme danger to anyone. I certainly have advised my own children not to take anything at school and put it in their mouth at all. Thank you. That's all I have.
Thank you, Senator Perry. So, first of all, I just want to say to the families that we really appreciate you all being down here today to testify. I met with probably, I want to say 15 or 20 families in my office last year. I think the governor invited a bunch of people down to meet, and I heard the stories. And, you know, I can't imagine what losing a child is like, especially like this. And I can tell you that my first experience with fentanyl was as a divorce lawyer. I had a child custody case where the other parent was addicted to fentanyl, getting it on legal patches on his arm. This is back before the pill scourge started. And my client was terrified a patch would come loose, the kid would get a hug, and their child would die. And I'd never heard of fentanyl until that case. This is probably 23 years ago or something like that. And then since then, obviously, the drug lords have figured out a way to create these cheap chemicals, to create these pills and mass produce it in a way that you can buy the stuff on the street for really extraordinarily cheap amounts, which has fed this problem. I think the policy difference that we're encountering on the committee here is what's the right way to attack this. And do we attack it the way we attacked things in the 90s, where we created lots of new penalties and mandatory minimums and new crimes to give prosecutors basically a lot of power to sort of leverage people into sentences, which is what often the result is when you stack up a bunch of charges? Or do we treat this more as a mental health situation, which I think Senator Boysko articulated that perspective a minute ago. I would say that at least I have communicated to the governor that I think we could find common ground on this issue if we focused more on focusing more on money to resources to catch the people who do this. The studies show that crime is deterred. We've had criminologists who testified to us during the pandemic on this committee that studies show that what deters crime is the risk of getting caught. If you do it, you know you're going to get caught, and then after that you're going to get convicted. And so from my perspective, Senator DeSteff's task force idea by itself has a little bit of merit from my personal perspective. I'm not speaking for the committee, and investing more money in the mental health side of this so we can reduce pressure on the demand side of the equation. But I think that's the policy difference we're coming up with. So having said that, I think Senator Boysko has a motion.
Thank you, Mr. Chair. Yeah, I just also want to remind ourselves, last year we passed a bill, and I was proud to vote alongside of you all that would have used the term that selling fentanyl is an act of terror. We have not seen a reduction in these deaths over the past year, but I agree with my colleague, Senator Serville, that really increasing our police oversight and making sure that we're doing that as best as possible. And with that, I offer an amendment to the substitute that would focus specifically on the task force and would strike lines 30 through 350.
34, 33. Mr. Chairman, I don't think that's Senate Bill 50.
No, it's Senate Bill 367.
367.
That's what's up on
It's
the board.
to strike, the motion is to strike lines 34, it's 30. Strike lines 30 through the balance of the bill, right?
Yeah.
Yeah, that's her motion. Is there a second for Senator Boysko's motion? Is a second for her motion? Is there discussion of the motion?
Mr. Chairman.
Okay, with Senator D-Stuff, you consider that friendly? Are you willing to, that might be the only way you get out of here.
Mr. Chairman, I just want to clarify, Senator Boysko, so you're referring to, so in line 30 through 34, that's existing code with the, that's existing code. So you're saying line 35 through?
No, 30.
We're taking out
She's just taking
30.
Oh, you're taking that out of this bill. Okay.
So you'd be
That-
stuck,
I would-
you'd have
I
a
would
task
say
force.
yes, I would be happy. That's a friendly amendment on this one.
Yeah. Okay. Okay, is there any discussion to the motion? Hold on, we have to do the motion first. Any further discussion? Okay, all those in favor of Senator Boysko's motion to take all the penalty stuff out of Senator D-Stuff's Bill 367, say aye. Aye. Anybody opposed to that?
No.
No. No.
Okay, I move we report the bill as amended.
Two noes. There's a motion to report. Well, it's all record, it's not a recorded vote.
Okay.
Okay, 3 or 4. Okay, now there's a motion to report Senate Bill 367. Is there any discussion? There's a second for that. Is there any further discussion about reporting the bill with the task force? And, I'm sorry, reporting, Senator Dees, you want to re-refer to finance?
Re-refer, motion, report, and re-refer to finance.
Okay, so there's a motion to report, re-refer that to finance, 367 to finance. It's been seconded. Any further discussion? None. Please open the roll.
Ayes 15, no zero.
Great, thank you, MJ. Now, we still have Senator McDougal's bill in front of us, which was Senate Bill 52, which is, and Senator McDougal, you said you wanted to say something. Do you want to have the last word?
Mr. Chairman, Senator Perry took a lot of it, but I do want to remind this committee, very familiar with the safe harbor statute because I pushed that forward. We worked with Senator Wexton when she was still with this body and then Delegate Hugo. That was something that was important. We had a former prosecutor from Hanover whose daughter was found in the closet by her dealer friend, and they could not convict him of distribution because she was dead and couldn't testify. The only thing they could convict him of at the time was disposal of a body. And as we look forward, certainly drug distribution can be a charge that can be brought. But it is much harder to bring a distribution and determine the correct jurisdiction when the person you've distributed that fentanyl to is dead. This gives prosecutors the ability to take the dealer that is dealing deadly substances off the street.
Okay, thank you, Senator McGuire. You want to have the
Mr.
last
Chairman,
word?
Yes, Mr. Chairman, members of the committee, we all agree on both sides of the aisle, too many people are dying in Virginia. We're looking for a solution. This bill is a deterrent. Texas and Nebraska passed this bill. They now have the lowest percentage of fentanyl overdose deaths of any state in the United States. This works. It is a deterrence, and I hope you'll vote yes.
Senator Woodshade, you want to say something? No. Okay. Okay, is there a motion? There's a motion to report. Oh, I'm sorry, it has to go to finance too, by the way. Okay. Okay. Okay, what's the substitute motion?
PBI.
It's been, is there a second for the PBI? It's been moved and seconded that we PBI the bill. Is there discussion for that?
Mr. Chairman, I'm sorry, going back to my question about, are we voting on Mr. McDougal, or Senator McDougal's bill or Senator McGuire's bill?
McGuire's bill was incorporated into McDougal's. We're operating from McDougal's language.
Okay,
It's
thank
his
you.
bill, his language.
Thank you.
Okay, so there's a motion to PBI the bill. Clerk will open the roll if there's no further discussion.
Ayes 8, no 7.
Mr.
Great.
Chairman, thank you for your time generosity.
No, it's a very important issue, and we need to give it all the time we can, so we appreciate it.
Sure, members of the committee, thank you very much for your time today.
Thank you, Senator. Okay,
Thank you,
next on
Tom.
my sign-up, I have Senator Favola with 2 bills. Is she still here? She left. Oh, my God. All right. Is Rouse here?
I can go.
McGuire, do you have another one, or is that it? Okay, Hashmi. Okay, so then we need to go to committee member bills until somebody gets here. You had one time sensitive, right?
I do, and same people, but I will make it very short.
Okay.
We don't need to say the same stuff.
He's got people here. Okay, Senator Obenshame, why don't we do your pill press bill? What was that? That was 469.
Mr. Chairman.
Senator Obenshame.
Mr. Chairman, members of the committee, I have Senate Bill 469, which is another fentanyl bill, but it's a different approach. Mr. Chairman, just a minute ago, indicated his belief that a better approach is to catch the people who do this. And what this bill does is it gives us a tool with which to do just that. This bill deals primarily with counterfeit pills, and this bill does three things. Number one, it elevates the penalty for violations related to adulterated or misbranded drugs, counterfeit drugs. It changes that, and I was surprised when I learned that that was simply a Class 2 misdemeanor. And many of these drugs are being counterfeited and laced with fentanyl, and it is a primary source of much of this poisoning. The second thing that this does is it criminalizes the possession of encapsulating machines or pill presses. And this is something that has broad bipartisan support. Congressperson Spanberger in Congress has called for federal legislation to ban pill presses and to criminalize the possession of pill presses which are used to make these drugs. And the third thing that this does is a number of years ago, up and down, well, across Virginia, we had a proliferation of meth labs. And these meth labs many of them were in homes where children were present. And we passed legislation that imposed penalties for manufacturing meth in the presence of children, because these children were being poisoned and killed through this process. And so the third thing that this does is it simply inserts the manufacture of fentanyl drugs, counterfeit drugs with fentanyl, to that legislation that we passed dealing with manufacturing meth in the presence of children. So it does three things. One, it enhances the penalty for counterfeit drugs. Number two, criminalizes pill presses. And number three, it criminalizes, it enhances the penalty for manufacturing in the presence of a child. That's it.
Senator, so I think I had some questions, I think, that council came up with looking at this about whether it was necessary to include on lines 42 through 44 the Romanette number 2, cocaine, coca leaves, or any salt, et cetera, in the bill, what the point of that is.
I'm sorry. Is there a question to me or to council?
To you.
Which is what?
Why we need to have, I know you're aimed at fentanyl, and that's picked up by Romanette number 1, I think.
Right.
But Romanette number 2, you've also got, these would be pills that contain cocaine, coca leaves, any salt compound derivative of preparation described in Schedule 2 of the Drug Control Act. Why that was needed?
You know, I don't know that anybody's here to drop a lifeline to me on that, but if it is the committee's desire to eliminate that Romanet.
Well, those drugs, I think the point is those
I hear you.
they're not nearly as dangerous. And
Mr. Chairman?
Yeah, Senator
I
Stewart.
hear and I
The way
understand.
I read it, and I may be reading it wrong, is if you adulterate those with something, then you would fall within the statute. And I think that's the purpose of it, but maybe I'm not reading it right. So if you adulterated cocaine with something,
This portion deals with the manufacture, deals with the pill presses and the encapsulating equipment, not the adulteration.
Mr. Chairman.
Yes, Senator. Mr. Benjamin.
I think the point is that Romanet 1 covers all Schedule 1 or 2 controlled substances. Because cocaine is a, Schedule 2 controlled substance, it would already be included. I think that was the point of the question.
Okay.
And so the bill, even if you took out Romanet 2...
redundant. It's redundant.
Mr. Chairman, yeah, if I'm reading this correctly, if you took out Romanet 2, cocaine would still be included.
Okay.
You okay with that edit?
Yes.
Okay, so the chair would entertain a motion to strike Romanet number 2 and make Romanet number 3 Romanet number 2. Is there a motion? It's been moved and seconded. We make that amendment. All those in favor say aye. Aye. Anybody opposed? Okay. Got it. All right. Any questions for Senator Obenshain? All right. Do you have people in favor? Are they online or what?
Mr. Chairman, what I would ask is, you've been very generous with the committee's time. There are people who are here in support of this bill as well as the prior bills, and if it would be the pleasure of the chair, I would ask that those who support this to stand, not to come up and speak, unless they have testimony specifically related to this bill. If you do, come on up.
Okay. Why don't we go 5 and 5, Michael?
So I'll try to be brief, and maybe I should have spoken more at length in the last bill. My name is Sean Foster. This is my son, who died January 31st, a year ago, from fentanyl poisoning. On behalf of my wife, we're here to talk about his story, specifically the fact that he died from what he thought was a Percocet. I don't know where it was pressed. I don't know if it was pressed here. I don't know if it was pressed in Mexico. It was pressed somewhere. It was sold to him by a college student in a college here in this state. It was the transaction took place online on January 28th. That pill was handed off to another high school student who was at that college that weekend on January 29th. It was delivered to my son on January 29th. He took it on January 30th, and the next thing I know, at 7:01 a.m. on January 31st, I get a call from my wife. I think my son is dead. I'm calling 911. I know the last bill already went by, but I think it's a little bit apropos, considering the fact that the 17-year-old that delivered the pill would apparently be convictable under current law. But the point is, for this bill, my son was dealt a pill that was a fake pill. And we've learned through this tragedy with my son is that basically all the pills are fake, whether it's an Adderall, whether it's a Xanax, whether it's a Percocet, whether it's others. They aren't even trying to make them real now. They're not even trying to get the real drugs and distribute them. They're all fake. These people that distribute these things for profit, like this person at this college that I can't name because his case is active, dealt for profit. He sold this pill that killed my son for $35 when it took pennies to make it. It's an all above the approach, from my opinion, my perspective. We retired in the state from the military after 21 years of active duty service because my son wanted to stay here. If I had left, he'd still be alive. Instead, he gets dealt a fake pill by a resident of this state that killed him. So we all have to do what we can in our capacities to deal with this. I am doing what I can. I'm standing here today. I've done videos with the Fairfax County Superintendent to try to get awareness out. It's been viewed 23,000 times. I've spoken to the media. I've spoken to kids. I've spoken to parents. We all need to do what we can. Your job and your capacity as legislators, what you can do is pass legislation that can help us get a hold of this from all aspects, not just a single focus. There's no one fix to this. Whether it's fixing China, that's a national security issue. Whether it's dealing with the border, that's a national issue for the states and for the national government to deal with. But there's things we can do here in Virginia that we can save our children like mine. And to the point, I think it's a sad statement that in our case, the Fairfax County Police Detective that has our case is a wonderful individual. He's doing everything he can. But when we told him that our son's case has gone federal because of work we did, he said he was glad because the laws in the state aren't sufficient.
If you're online and you would like to speak to this bill, please raise your hand electronically.
Oh, okay, I'm sorry. As a police officer, I went to many cases, and the users can't get help until they want help. So we can offer so many services, so many programs, so many places that they can go to get help for their addiction, and they don't take advantage of it. We go to call after call after call, just as before I was an officer, we did for domestic violence cases. And it's no longer acceptable to tell the other spouse to take a walk, because they'll come back and they'll kill the spouse. So we had to set hard laws that a mandatory arrest was going to be made when we saw physical injury. So here we have an addicted person that's not taking advantage of the services that are provided to them, and we continually go to these cases. The other thing is my son died from a pill, a pressed pill, that had 3 different types of fentanyl. If someone wants to play science in their home and create a pill that can ultimately kill another individual, then that's an accountability issue. Yes, it was distributed, but it's 2 different charges. We have to look at the faces of the individuals. My son was never arrested, never detained, never in rehab, never even suspended in high school. So there's a different demographic than looking at an addict and an individual, which my son was. So we got different people, but people are people.
I just want to add, I'll be very brief. I'm very empathetic to those struggling with substance use disorder. I work in schools with the DEA, the U.S. Attorney's Office, with the Silent No More campaign. Those that are struggling, I have a very soft spot for them. The man that sold the pill to my brother was not someone who used drugs. He purposely addicted him in a huge community where he lives. This man is still there. He is not someone who's actively addictive. He called my brother's phone 3 times at night at 11 p.m. I can't help but wonder if he was checking to see if he was alive. I know more people go to him because my brother died. He picked up business off of my brother's blood. Thank you for your time.
Thanks. Okay, is there any, MJ, is there anybody online? Okay, is there anybody opposed to the bill?
If you're online and you're opposed to this bill, please raise your hand electronically now.
Nobody. All right, Senator Obenshain, one question we had up here. I mean, I've been Googling around, and apparently you can buy pill press machines online. I didn't know this until your bill popped up in front of me a minute ago. So is there any kind of legitimate reason that people have pill press machines at home and use them for their individual use? I've never heard of it, but I'm just curious.
Not to my knowledge, Mr. Chairman, and there are a lot of things you can buy online that are not legal in the Commonwealth of Virginia. This bill is, and this portion of the bill in particular, it ain't geared towards addicts. This is geared towards people who are deliberately manufacturing this poison.
And I just noticed, Senator Obenshain, that NIH says federal law prohibits the sale, possession, use of an unregistered pill press under federal law. This would just provide a corollary under state law, I guess.
That's what we want to do.
Okay.
My understanding is that the federal law, and I'm not aware that this is not my area, but I'm not aware that there is an effective federal law, and that's why I mentioned Congressperson Spanberger's support and call for this very provision.
And Senator, just one more thing. I think would give us a little bit of comfort in the bill, just so we're clear, if there were subsequent attempts to amend this bill to add other types of crimes to it that we would view as being unrelated to this specific bill, would you resist those types of amendments?
As I told the chair, this isn't a vehicle to anything else. This is a vehicle to just this, and I would resist any efforts to make any substantive broadening of this legislation.
Okay, great. I think Senator Boysko has something to say or a motion, I think.
Thank you, Mr. Chair. I appreciate the patrons bringing this bill forward. I think it really gets to the heart of the matter of the people who are actually doing the harm, as opposed to the individuals who might inadvertently be selling something that they think is a different substance. At the appropriate time, I have a motion.
What's your motion?
Right. I move that we report as amended and refer to judiciary.
Finance.
To finance. Excuse me. We're in judiciary.
Okay, it's been moved and seconded. We report and refer the bill to finance as amended. Is there any other discussion about the bill? Okay, clerk, open a roll.
I thought I moved you up there, sir.
There we go.
Ayes 13, no 0, abstentions 2.
Mr. Chairman, thank you.
All right, thank you, Senator Obenshain. Senator Rouse has been exhausted by how long we've taken, and he's asked that his bill go by for the day. Is there a motion to take Senate Bill 355 by for the day? It's been moved and seconded. 355 go by for the day. All those in favor say aye. Anybody opposed? Okay, that's by for the day. That brings me back to, is Favola? No, Hashmi's here. No Favola. Okay. Senator Hashmi, this is your data bill that we had up on Monday?
Yes.
What bill is that?
This is SB 236, Mr. Chair.
236. Go ahead.
And there is a substitute, Mr. Chair.
There's a sub. Okay. Is there a motion to adopt the sub? Is there a motion to adopt the sub? It's been moved and seconded. We adopt the sub. All those in favor say aye. Aye. Anybody opposed? No. Sub's before you. Okay, Senator Hashmi, fire away.
Thank you, Mr. Chair. The substitute basically addresses some of the concerns that were raised by the Office of the Executive Secretary of the Supreme Court in terms of the amount of information that would be requested through this data collection and the kind of fiscal impact. So we worked strenuously to really redefine and narrow the scope of the request. And we also brought down considerably the kind of fiscal impact that it would have. So just briefly, SB 236 is seeking to address an issue that we have in the Commonwealth. You know, Virginia has the dubious honor of having some of the highest eviction rates per locality in terms of a nationwide assessment. 5 out of the 10 top localities that are identified as having high eviction rates are located right here in the Commonwealth. And we have tried strenuously over the past many years to address the eviction crises in Virginia, but we don't always have the data that's necessary to make good public policy. And so this is a fairly narrowly defined bill, but what it seeks to do is to give our researchers at our four-year institutions the ability to collect comprehensive data and to be able to analyze it so that we may effectively be able to address our concerns on the eviction crises through effective policy measures. This is geared really towards authorizing full-time faculty at our baccalaureate institutions to get aggregate court data that isn't currently available online in unlawful detainer cases and other civil case types that are related to evictions for the purposes of academic research. The only information that would be available are unlawful detainers, the return writs of eviction, and the warrant and debt, as well as garnishment. And this would help us to gather sufficient or better data in order to actually put into perspective the kind of eviction issues that we face here in Virginia. And that's the general scope of the bill, Mr. Chair.
Senator Hashmi, does this only relate to civil case data, not criminal data? Is that right?
I'm sorry, I couldn't understand.
Does this only relate to civil case data and not criminal case data?
Yes, that is my understanding.
Got it.
Mr. Chair.
Senator Deeds.
Is there anybody here from the Executive Secretary's office? I'd like to know. I'd like to know why this information can't be gotten anyway. It's public information. Going to court is a public process.
Good afternoon.
Why do we need a bill for this?
Mr. Chairman, members of the committee, Senator Deeds, the existing language in the statute already allows any member of the public to request aggregate case data from our office and provides a procedure by which we provide that. It allows us to release any of the information that's currently available in the online case information systems, except for party names and date of birth. So the reason for that is that that information, once it is provided in bulk to a requester, is out there in a way that is no longer under the control of the court system. So if cases are subsequently sealed or expunged, that information is now out there with party names associated with it.
Of course, the civil case is not going to be sealed. So the operative section of this code of this statute is really on line 61 that allows 61, 62 that allows party names and addresses to be disclosed.
Mr. Chairman, Senator Deeds, there is now a law that allows for expungement of unlawful detainer cases. Okay. So this would allow university researchers to obtain that information that includes PII, personal information of parties to unlawful detainer actions, but exempts it from FOIA and requires that they protect that information.
And I would also note for the committee, there's legislation pending, at least in the other body, maybe in this one too, to make the expungement of unlawful detainers, dismissed unlawful detainers, automatic. So there's going to be a much higher volume of expunged unlawful detainers if we pass that bill and it's signed by the governor. So that's also a thing. Thank you. Are there any other questions for anybody? Huh? Oh. Any other questions? Senator Stewart.
I'm just trying to digest it. And I guess a lot of these cases are available at a particular general district court somewhere, but they're looking for it in an aggregated form from the Supreme Court's database. Is that what I understand? I just want to make sure I understand. I do have a question.
Except the expunge stuff.
Yes, Mr. Chairman, Senator Stewart. Of course, the case information is open to the public except for expunged cases. You can walk into a general district court clerk's office and request a case file, and they'll provide you with that case file. What this section of the code does is allow a member of the public to come to the office of the executive secretary and request reports of aggregated data. So that's data that our office programs to extract from the case management system used by the clerk. So this is the case data entered into the case management systems by the clerk. It's not images of the records that are filed with the court.
So a silly question. And I note that the bill, they have an obligation to protect the privacy and security of the report. They're not supposed to release it to the public. And I realize it's already public. But what if one of these individuals whose data is being sought and utilized is in fact injured by this? Is there any liability? Is there any accountability to the institution that's using it?
Well, I can't speak to the institution, Senator Stewart, but there is existing language in that section of the code that protects the Office of the Executive Secretary and the Clerk of Court from any liability in releasing information. Perhaps Senator Hashmi or the individual she is working with on this bill may be able to address that question as to any liability on the part of the institution.
Senator Hashmi? And I just want to know if somebody is injured as a result of this, an individual, a person, whom can I sue for that, and how much can I get that person in damages as a result of that injury that they get?
I may not be able to answer that question to your full satisfaction, but this is data that would be requested by researchers at these. For instance, at Virginia Commonwealth University, we have the major center, the Eviction Lab, which works on gathering the information and the data, and so the aggregate data is the handling of that aggregate data is the responsibility of the researcher. The protection of that research materials is in the hands of the researcher and the institutions, just as any research opportunities that the university may be engaged in, as our four-year institutions are engaged in high-level research in many different capacities. They have institutional and research responsibilities around that information. And so those concerns would apply to this data as well.
Mr. Chair.
Senator Deeds.
I would ask that this bill go by for the day.
Okay. Senator Hashmi, I think we need to have a little more dialogue about it. So you cool going by for the day?
That is the decision of the committee, and I certainly respect it.
Probably a good idea, I think. So, okay. All right. All those in favor say aye. Anybody opposed? No. We'll talk about it and probably see you Monday. Okay.
Thank you, Mr. Chair.
Thanks, Senator Hashmi. Okay, who we got? Has Favola shown up yet? Okay, Senator Boysko has a really easy one. Senate Bill 157, I guess. Yeah. 157. Oh, yeah, this is that press association publication thing.
That's my bill.
And it's a spin on it, I think.
This is the one with the
Successor to my bill from last year.
Huh? Okay. All right. Senator Boysko, go ahead.
Thank you, Mr. Chair. Mr. Chairman Serval, I have SB 157. It is a bill to enable online-only news publications to publish public notices. As you may remember, Senator Obenshain had a similar bill last year, and after session, the Virginia Press Association worked with the online-only news publications over the summer and the fall to create a process using our current statutory structure to allow online-only news publications to qualify to run public notices. As you know, that there are many locations who no longer have a paper in physical paper any longer. This would allow online news to qualify. The bill in front of you today represents the peace in the valley between the two groups and a narrow expansion of what will qualify as a newspaper of record. To make sure that the online-only newspaper publication represents the community accurately, SB 157 sets forth specific standards for online-only news publications. These standards include employing local news staff, maintaining a dedicated domain name, and providing regularly updated general news coverage of the area where the public notices will be published. Think of the patch. In addition, the online-only news publications will have to petition the court to be certified to run the notices, which is exactly the same process free papers have to do now. Finally, the bill requires them to archive the notices for 3 years and provide verifiable electronic tear sheets to prove that when the notices were run, just like newspapers have to do. Looking forward to working with fellow legislators, stakeholders, and the public to pass this bill, and I think that there may be someone in the audience who wants to testify, but I don't know if they're still here.
Senator Boysko, we're trying to throw a lifeline to our local news sources to try to provide them with a little bit more revenue so they maybe survive a little longer. We're losing a lot of them, is that right?
We are. And Mr. Chair, there are also, as you are aware, there are lots of places where physical newspaper is no longer an option for a community.
Great. Okay, is there anybody in favor of the bill?
If there's anybody online who would like to speak to this bill in favor, please raise your hand electronically.
Be careful what you say. You're probably in pretty good shape here, so I think.
The longer you talk, the more likely you're going to kill it.
Yeah. Okay.
Mr. Chairman and members of the committee, my name is Randy Arrington. I'm the publisher of PageValleyNews.com. We cover Page County in the northern Shenandoah Valley, and I strongly support Senate Bill 157 because it provides greater access to public notices for citizens, more options for local governments in publishing these notices, and a path for sustainability for community journalism.
My name's Chuck Jackson. I'm editor of the Mad Rap Recorder and the Green Journal covering Madison, Rappahannock, and Greene counties. I support this bill and appreciate any consideration.
Thanks.
Good afternoon, Amy Perrin-Seibert on behalf of the Virginia Press Association, and we support the bill. Thank you.
Thank you.
Okay, I think we have one person online. Can you call the person online?
Scott Broadbeck, you can unmute and speak.
FFX Now covering Arlington, Alexandria, Fairfax County. Here to strongly support the bill. Thank you.
Great, thanks. Okay, is there anybody in opposition to the bill?
If you're online and you're in opposition to the bill, please raise your hand electronically.
Okay, is there a motion?
Mr. Chairman, move to...
Is somebody in opposition?
Anne, you may unmute and speak.
Yeah, just briefly, I don't know that I'm in opposition except for, as a person that has to look up this information, I hope that there's something in this bill.
Ma'am, Miss Gregorian, the policy that we adopted is that if you're going to testify to a bill, you have to have your camera turned on, you have to testify who you are, and if you're with an organization, identify the organization, and then you can testify.
Okay, is that good enough? I'm not with an organization.
There, we can see you now. Okay, good. And tell us who you are, where you are, who you're with.
My name's Anne Gregorian. I'm in York County, Virginia, and I would like to say that I hope that this bill I would oppose this bill if it doesn't have a provision that the government agencies that are using online posting would be required to list where they are posting this information, the web address, links to it, somehow to make it easier when I'm looking up an item, that I just go there and I click on that to see what they have put as a notice or where they're posting notices as a matter of general rule. Thank you.
Okay, thank you. Okay. Is there any, I think that takes care of all the opposition, right? I'm sorry, Sabrina, Council, you have a question?
No, Mr. Chair, I was just going to say that on line 89 of the bill, number 7, have a clear and easily found link to public notice section on its website homepage. That addresses her
you're
question.
Just pointing out that I think responds to the concern identified by the person on the Zoom. Is that right? Okay. Okay. I think Senator Obenshain had a motion.
Move to report.
It's been moved and seconded. It's just no finance. No finance. So we report. It's been moved and seconded. We report the bill. Clerk will open the roll.
Ayes 15, no 0.
Great.
Thank you.
All right. Thanks, Senator Boysko. I think we got Perry, Deeds, and me who are still here.
Well, the bill, do I have? Okay, well, we were waiting on some language, and we don't have it yet, so we might have to take my bill back for the day.
Okay, so I'm going to wait on yours. Senator Perry, you have one still? Yours went by? Okay, that leaves, I think, me, unless Favola, I've heard, is chairing a subcommittee she's stuck in. So we might have to do, I think we're left with me then, right? Who? Senate Bill 393. Senate Bill 393 by Perry. 391? Oh, yeah, Senator Perry, is that your carnal knowledge bill is still here. Does that need to go by for the day, or are you ready to present? Okay, so there's been a motion to take Senate Bill 394 by for the day. It's been seconded. All those in favor say aye. Aye. Anybody opposed? No. 394 is by for the day, so I guess that leaves me then, right?
341.
Right? Okay. 341. Senator Deeds, all yours. Take over the mothership.
Okay, Mr. Chair. I might just take over. 341. 341. You got 2 minutes.
Thank you, Mr. Chairman. Senate Bill. You've really taken over, haven't you? 341 is a bill from the Housing Commission. You all didn't hear it last year. It was actually heard in general laws because it relates to homeowners associations, but it's really about foreclosures and probably properly better belongs here. But so I think it was in 2020, Delegate Torian carried a bill that said that you're not allowed to foreclose on somebody's home unless there's at least $25,000 at issue. And however, I don't think what anybody realized at the time is that there is separate authority in the code that allows a homeowners association, a condo, or a co-op association to initiate a foreclosure on somebody's home for any amount of money, even $1. And there were HOAs in the state that were initiating foreclosure proceedings over like $300-400. And when that happens, the trustee and the attorney involved immediately slap it with a $4,000, $8,000 of attorney's fees, so that you can't end the foreclosure proceeding over $400 without paying $9,000 or $10,000.
Mr. Chairman, is this same language we did last year?
No.
Okay.
No. And so, we got a sub. Okay, I'd move my sub.
There's a substitute for the bill to get it properly before us. Is there a motion to adopt it?
So moved.
Been motion and a second to adopt the substitute. All in favor, say aye.
Aye.
Okay, that's the bill before us, a substitute for 341. Senator Servell.
So last session, I proposed that there be a $5,000, at least $5,000 of assessments at issue, exclusive of fees and attorney's fees, before you're allowed to initiate a foreclosure. The HOAs got all bent out of shape about that. We went to the Housing Commission, negotiated. The result that came out is that we got a $5,000 cap on you're not allowed to initiate a foreclosure unless it's $5,000 at issue. But they also said that the lien associated with that they can put on a house has to extend for 10 years, so they're not under pressure to foreclose in 2. The existing lien only lasts 2, so they want a 10-year lien instead of a 2-year lien. And then I also insisted that if they're going to have a 10-year lien, that there be language in the bill that requires them to maintain records of the assessments, so that there's a dispute in 7 or 8 years, they still got records, so they can fight about exactly what it all originated out of. But that's basically what the bill does. It basically sort of makes it so an HOA can't take your house over like...
Does anybody have any questions of Senator Servell?
No, the HOA industry is cool with it.
Is anybody against this bill?
Is
there a motion?
Second.
Been a motion and a second to report the bill. Report the substitute? Does it have to go to finance?
No.
Okay. Are there other motions? Open the roll.
Second.
Ayes 13, no 0.
Okay, your bill reports.
Okay.
Do you have another?
No, I think that's it for today.
Then we'll rise.
Yeah, we're done. Senator Stanley isn't making it back in time. The motion bill go by for the day has been seconded. All those in favor say aye. Aye. Anybody opposed? No. Okay. Now we're done. Committee will rise.
Trying to redeem yourself with the speed of that.